Dr. Cole.
Mr. Chairman, I have an amendment at the desk, and I request that be accepted as read.
Offered by Mr. Cole.
Without objection.
This is a partial solution to a vexing problem. In 1887, Indian tribes had about 148 million acres of land in the United States. By 1934, that had shrunk to 48 million. Congress at that point took an important action and took Indian-owned land into trust and retained the right to add to that land base. In the time since then, tribally owned land has moved up modestly from 48 million to 56 million acres. In 2009, the Supreme Court, in a very narrow interpretation of the original rule, said you had to be listed in the 1934 Indian Reorganization Act to be eligible for land being taken into trust. Now, the reality is we have tribes that are hundreds of years old. The Narragansetts come to mind. They were actually the subject of that case, that have treaties with the colony of Rhode Island. They've been in the same place for a long time. They're not listed in the Indian Reorganization Act. They were a state-recognized tribe, not a federally recognized tribe. We have tribes that have come into existence since then, or been recognized since then, that have land bases that everybody assumed were appropriately in trust. Indeed, for 75 years, Republican secretaries of the Interior and Democratic secretaries of the Interior assumed they had the right to do this, and it was so recognized. This court changed that, effectively creating two different kinds of Indian tribes, a group that the federal government could put land in trust for, and a group that they could not put land in trust for. And in many cases, those tribes already owned land. What happened is not surprising. The tribes that were not listed immediately became subject to lawsuits by states and localities for taxes. Now, everybody always assumes this is about gaming. Over 98% of the land, by the way, we're talking about here, is not used for any gaming purpose whatsoever. It's housing, it's economic development, it's very traditional use of lands. It's sacred sites in some cases. So, if I had my way, we would fix this all the way to the current date. The administration actually would like us to do that. And this committee in 2010 did do that. I actually made this offer to fix this in the Interior Appropriations bills. The Democratic majority thought this is a good way to do it, actually respected that full fix. We passed it across the floor of the House, couldn't get it through a Democratic Senate at the time. Since then, Ms. McCollum and I both have bills that deal with this that would go all the way up to the president. That would be my preferred solution. However, there is another committee that has jurisdiction in this matter. It's Natural Resources, and so we've been working with them to get to at least a partial solution and protect as many tribes and as much Indian land as we can. So in an agreement with the Natural Resources Committee, working very closely with the chairman of the subcommittee, we all sat down and they were willing. They have our legislation. They have Ms. McCollum's legislation, my legislation, which we would both like to be dealt with. I would be thrilled to support a bill. But we could at least persuade them to go up to 2009, which is the point of the Supreme Court decision, and say anything taken into trust before then is protected, is not subject to lawsuits. Now, we would still have to deal with it going forward. I would continue to support legislation that would do that. But if we can take a lot of tribes and a lot of Indians out of harm's way and frankly end this legal limbo in which many, many tribes are trapped and which they're spending millions of dollars to protect themselves in litigation, we should do so. So with that, Mr. Chairman, I would propose the adoption of the amendment.
Chairman Calvert.
Thank you, Chairman. I rise, obviously, in support of the gentleman's amendment. This subcommittee is constantly working to correct disparities in Indian country, not only because it's the right thing to do, but because it stretches limited appropriations further so that we can fix up more schools, hospitals, and roads. In 2009, the Supreme Court created this disparity, which is described by Tom, and by granting exclusive land rights to tribes formerly recognized by the federal government before 1934 as opposed to those recognized later. The ruling puts at risk millions of acres taken into trust since 1934, many of which have been developed to provide tribes with basic human services and sources of revenue. The revenue and tax implications of taking these lands back out of trust would be devastating to the tribes and would place additional burdens on this bill. The amendment reaffirms that any land taken into trust for any federally recognized tribes before the Supreme Court ruling may be continued to be held in trust. Let me be clear. The amendment only pertains to lands taken into trust from 1934 to 1939, or 2009, excuse me, 1934 to 2009. The amendment does not touch the controversy surrounding the surge of lands taken into trust under this administration in order to meet acreage goals without regard to local concerns. This is a compromise forged within the authorizing committee, and I applaud Mr. Cole for working to find some common ground on this, and I certainly encourage a yes vote on the Cole amendment.
Ms. McCullough?
Thank you, Mr. Chair. I rise to just share my concern on the record about this provision. Mr. Cole and I and many of you are members of the Native American Caucus. We do share a deep concern about the turmoil many tribal nations are facing due to the challenges of the status of their land. Along with many of you in this committee, we have been working on bipartisan legislation that would fix the misinterpretation of congressional intent in the Carcieri decision, which created this crisis. And also, as been pointed out, there are bills that would reaffirm the status of land that have already been put into trust for tribal nations. And as been pointed out, it's the intent of the Indian Reorganization Act of 1934 to turn a page on a disastrous, divisive policies that strip tribes of their lands and instead recognize the right of all federally recognized tribes to restore their homelands. Trust lands, as Mr. Cole has pointed out, are fundamental to a tribal's ability to self-govern, to provide housing, to build health care facilities, and otherwise support their communities using the very BIA and IHS services we fund in this bill. The congressional reaffirmation of this status of lands placed into trust should be unequivocal, and it should say, once a government has placed land into trust for a tribal nation, we will honor that promise. Now, this amendment, however, places a condition on that reaffirmation of land trust, and I have concerns with that. By only going up to those lands prior to February 22nd, 2009, we, with the best of intentions, would be creating further divisions that declare trust lands before a certain date are to be respected and others are left to be questioned. Well, this is the dilemma we're faced with today, and Mr. Cole is trying to do his very best to at least move things forward. So I hope that we can continue a dialogue as we do move forward, so all of us acting together with all of Indian country can come to a situation, a solution that everyone can support. I look forward to working with the chairman. I look forward to working with Mr. Cole. I look forward to working with all of you, and most importantly, everyone in Indian country. And with that, I yield back.
Mr. Cole is recognized to close.
Thank you, Mr. Chairman. I couldn't agree more with my good friend, and I want to state emphatically that we ought to go all the way through. We ought to do that. We have tried for years to move this across the floor. We've had bipartisan support, bipartisan opposition. Any administration, I will tell you, Republican or Democrat, would be for this legislation because no administration wants to administer two different kinds of Indian tribes. It's just ridiculous, and it's a trial lawyer's dream come true. And frankly, we have lots of we have states and localities that sometimes exploit this to try and get tax revenue and things that they're really not entitled to. They're supposed to go to tribes so they can run their government. They don't have the power to tax. This is at least a partial solution. This would protect many, many tribes, but it's not the final solution. It should not be considered the final solution. And I'm going to continue to work with my friends on both sides of the aisle so that we can get this thing settled. But if we can make this much progress, protect this many tribes, take this many millions of acres out of being subject to dispute, I think we ought to take the opportunity to do it. With that, I yield back, Mr. Chairman.
Question